by government academic institutions or government research labs. So these are the range of policies that have direct influence on the adoption of free and open source software, and every country must pay particular attention to these policies. Next we move on to the area of schools and colleges, and here there is a range of things that we need to worry about. What the curriculum being mandated is, what the software installed in the labs are, what the other software in the ecosystem of education are based on, etc. In a sense, a particular country trains its young people only in the use of proprietary software. What it, in a sense, is doing is the business model of proprietary software companies. So, in order to ensure that young people learn generic skills, the concepts, the young students of Saudi Arabia are able to grow up and become computer engineers and scientists and not just computer operators, then it becomes particularly necessary there to be also reform in school and college curriculum, and I consider all of that part of the policy framework within a country. Can we move to the next slide, please? Looking now with a little bit of detail at copyright law. So, even though India did not sign any of the internet treaties at the World Intellectual Property Organization, recently, and that is only 2 or 3 days ago, an amendment to the Copyright Act was introduced into Parliament. And of particular importance is how India decided to deal with digital rights management and technical prevention measures. And what India did is, in some senses, particularly smart. One would have to look at the final text. What we have at the moment is still only drafts. One would have to look at the final text, read it also very closely, but from first impression, it appears that many of the traditional provisions available under fair dealing and fair use, such as trying to make competing or interoperable products and services, backing up one's data, ensuring one's privacy, conducting research, studying at home, studying in a non-profit fashion, or maybe even studying in an academic institution. All these provisions, all these uses could be considered valid reasons for breaking the digital rights management and for breaking the technical prevention measures which have been installed either on a piece of content or on a software. And this is important. If free software has to compete with proprietary software, then we must be able to understand the formats of the documents, formats of the settings within an application, etc. So fair use and fair dealing must be protected, and this can be done in full compliance of WIPO treaties, even if you have not signed the treaty, but you are under some pressure. Either the US Trade Office wants to give legal sanction to DRM or TPM. That can be done, but that can be done in a proper, balanced fashion, which ensures that the free software ecology in the country continues to grow. It's also important to ensure that end-user license agreements don't override exceptions and limitations under copyright law. And this could be dealt with either within the copyright law of a country, or it could be dealt with within contract law. And then the final bit to worry about in copyright law is there shouldn't be any explicit statement against viral licenses or copyleft licenses as we have in the GNU GPL. It's important for copyright law either to explicitly endorse such licenses or to remain silent on the matter. Can we have the next slide, please? When it comes to IT law, again, there might be several things that need to be in place. The first is intermediary liability. And again, in India, in 2008, the IT law was amended, and at that point, intermediaries were absolved of all liability that might emerge either from copyright infringement or from libel, etc., if they exercised sufficient due diligence. And that is, again, something that would be necessary to ensure the growth of free software. There was a project, a free software project called Playfair, which tried to allow people who had bought music from the Apple Store to allow them to play that music on their Linux desktops. And that project shifted to India, and Apple sent a legal notice to the web host, and then the project had to shift again from India to some other country. So in order to avoid such complications, intermediary liability in IT law is particularly important to focus on. Yes, most countries have this, and Saudi Arabia as well. Electronic contracts and digital signatures should have legal sanction. Again, viral contracts could be dealt within the framework of IT law, and that's another opportunity to clarify such matters. And on the question of liabilities, it's important for contract law and perhaps contracts under IT law to allow the creators of software and web services, in particular those who are distributing free and open source software, they should be able to ask the consumer of the software to absolve the creator of the software of all liability. Next slide, please. With patents, what we have noticed is after countries across the world started to adopt free and open source policies and also open standards policy documents, patents, the main weapon for proprietary software companies to attack free software companies and free software adoption. In particular, you know the famous case of the MP3 patent. The patents are owned by Fraunhofer Institute and Thomson Electronic, and it becomes particularly difficult for ordinary people to adopt free software, because the moment they adopt free software, they lose support for their common file formats, in particular video formats and audio formats. And this has been a major stumbling block. Not only legacy data being the stumbling block as far as patents are concerned, but also the threat of legal action. Proprietary companies keep threatening various free software companies and free software projects with legal action, and that can affect the adoption of such project and the morale of the people working on such a project. So the best case scenario, and this is there in many countries, and some people would interpret Indian law to mean this, is that software is non-patentable subject matter. That would be the best case scenario. This can be also clarified through practice in the patent office or through a verdict from a court, if it is not really clear from the word of law. The minimum is that software can be patented only in combination with hardware, and some countries have adopted this path. And the worst case scenario is that software patents are allowed, and that's indeed a terrible situation as far as free software is concerned. But if there are high patenting standards, and if there is a very capable patent office, then they can make sure that most software patents, and in particular most software patents that we know today, are of very poor quality. At least the patent office will make sure that those software patents, especially those that affect free software, are blocked and are not granted. Patents are not issued on those applications.